our contention is those requirements are not met with your lordship.
How is stockpiling different from commercial stockpiling?
Commercial stockpiling is what is being prohibited, your lordship, and I have further arguments.
What is your problem statement say?
Commercial stock. We are alleging that there is a commercial.
You are alleging. What is the problem statement?
The problem statement does not have any factual representation of it.
Does it say commercial stockpiling or stockpiling?
The problem statement is silent on the aspect of whether it's commercial stockpiling or not, your lordship.
It just says stockpiling.
And it does not say that.
Why are you getting stockpiling from them?
Also based on the fact that our market intelligence team uncovered data and the fact that they are able to secure a manufacturing license which requires a certain amount of manufacturing capacity, we are placing the allegation before this court to conduct an inquiry, your lordship. We want to make sure that they are not commercially stockpiling this. That will be part of our prayer as well. Your lordship is
Either under the judgment or under the act. Is there any scientific formula which is given to what would be the exemption, what would be the amount, or is it just
Lordship,
each time it varies?
It varies on a case-to-case basis, your lordship. However, for determining the said criteria in each case, these guidelines ought to be followed, your lordship. Which is, which country are they exporting to, how much is required, how much quantity is required for seeking approval there, and how much is being manufactured by them for the purpose of seeking approval. So these guidelines have to be met with, and it is our allegation in the present case that it is not met with. The burden is upon the defendants to present at least an affidavit before this court that it has been met with, your lordship. Because they are the ones claiming the polar exception. If your lordships are satisfied, may I move on to the next?
I'm just wondering because your market intelligence team is what you are relying on.
Certainly.
To say that there is a commercial scale of production.
Certainly.
So there is no number that you are assigning. So your assumption that it is a commercial scale of production or commercial stockpiling must base on what is the number that is required for regulatory approval, by what percentage has that exceeded, if not the number of tablets as in this case at paragraph 112. But as much as you say that they have not filed any affidavit, you don't seem to have any details on that.
Lordship, us entering into their premises and finding out the exact quantity of drugs that they are manufacturing.
Exact quantity need not be. That's why I'm saying give a percentage, saying what is required for regulatory approvals in these two countries is, let's say, 50 tablets.
Certainly, Lordship.
They are because you have a report from your intelligence team. I'm assuming therefore that they have some tangible numbers that give rise to the cause of action for you to initiate the present proceedings.
Your Lordship, our concern is not only with the report that they are commercially stockpiling, Your Lordship. Our concern is that.
For bowler exemption, what else is there?
Certainly, it is with regards to commercial stockpiling. But our concern is that once the patent expires, the manufactured goods, before the patent has expired, they would still be infringing goods. They are looking to just commercially stockpile and push it into the market.
Correct. So 107A protects them in terms of the exception that is granted by
for the purpose of exporting.
Therefore, it is not in dispute that they are manufacturing, right?
Certainly,
that is not the issue here at all. What is the scale of manufacture that gives you the right to sue them now?
Also, we are concerned that there might be a commercial stockpiling, and in addition to that, the fact that they have acquired a market.
Your assumption, you say might be commercial stockpiling. Can a court grant any prohibitory order?
Also, in this very case, Players Union of India, where these guidelines were laid down, there was a prohibitory injunction granted against them.
Yes, there under 112, paragraph 112,
they were
at least there is a number.
Much of it, they were able to come to the number because an inquiry was conducted. We are at a stage where
it says citizen did not conduct an inquiry, but there was export there. Here there is no export, at least from the problem statement. It is only manufacture and stockpiling.
Certainly, Your Lordship, they are manufactured and stockpiled, and we are aware, based on the fact that they have acquired a manufacturing license, of their capacity to manufacture. If we have an apprehension of danger, we are allowed to initiate a court-timid action against them, seeking for an injunction and an inquiry to make sure we don't suffer any damages as well.
Absolutely, that is the concept of a court-timid action, but there has to be a prima facie case, is it not?
Certainly, Your Lordship, if I may substantiate with another judgment, which is ER School versus Zydus Life Sciences, it's a 2025 judgment, very recently, and the facts are identical to the present case. In that, local Indian company tried to research or commercially stockpile a variant of a patent-protected drug, and their claim was that it would fall under the polar exception. We have given it in flag number 7, Your Lordship. Apologies, Your Lordship. It's page 215, page 215, Your Lordship. This is the judgment of the ER School case.
That's like good.
This was Delhi High Court, Your Lordship, which is pari media to the present court. Your Lordship, page 215.
So you mean the operating portion?
The operating portion. Yes, Your Lordship. Your Lordship, essentially, what happened was the plaintiffs had to establish a prima facie case. And second was with regards to the balance of convenience. Balance of convenience can be substantiating with issue 2. Once both were established, the defendants were prohibited from launching or manufacturing any of their drugs, Your Honor. With regards to prima facie case, I will be arguing in issue 2. And with regard to balance of convenience, both of those fall under issue 2. With regards to whether Bolar exemption will apply or not, our allegation is that there is commercial stockpiling. We are not in a position to give the exact amount or even an estimated amount of what exactly they are capable of. Our information is restricted to the fact that they are commercially stockpiling, Your Lordship. So we are requesting this court to conduct an inquiry, seize their manufactured goods.
Which court conducts an inquiry and collects evidence?
That
is upon the plaintiff to establish. The court never collects evidence.
Your Lordship, counsel ready.
Inquiry will be limited to the material that is placed before the court. Where you show something, and then the court applies its mind to see if that satisfies the requirement for a prima facie case or what defense the defendant has. The court cannot, go collect evidence on behalf of the plaintiff.
Much obliged, Your Lordship. We are asking this court to pass an order for seizure, Your Lordship, which is within the scope of the Patent Act.
And only if you establish your prima facie case. You can't.
That I'll be arguing issue 2, Your Lordship. I will substantiate the same. My contention is that I am not in a position right now to exactly point out the quantity, Your Lordship. What I am aware, as per the facts, is that there is a commercial stockpiling. Once an order for seizure is passed, after I prove that there is prima facie infringement as well, then we will be in a position to properly substantiate it and seek for an injection, Your Lordship. Moving forward with my argument of the final limb of issue 1, Your Lordship, with regards to the international principles on stockpiling. If I may direct your attention to flag 11 of our compendium, page 217 is the next one here. This is the case of Canada versus the European Commission. 107A is identical to Canadian laws section 55 clause 1 of the Canada Patent Act. 55 clause 1 also allows for a similar exception, which is that they are permitted to export to another country for the purpose of manufacturing. But Canada also had a 55 clause 2 which permitted commercially stockpiling, manufacturing and storing the drug itself for the purpose of selling the generic variant right after the patent expires. Both of these sections were challenged by the European Commission before the World Trade Dispute Settlement Body. And what the Dispute Settlement Body held was that 55 clause 1, which is 107A in India right now, that falls under the 3-step test given in Article 30 of the TRIPS. The Article 30 states that exceptions which are granted, they must be limited, they must not unreasonably conflict the normal use of patent, and they must not unreasonably prejudice the patent owner's rights. So 55 clause 1, which is synonymous to 107A in India, was held to be valid by the Dispute Settlement Body. 55 clause 2, however, Your Lordship, as the highlighted portion I have to read out, the panel concluded that the stockpiling exception of 55.2 constitutes a substantial curtailment of the exclusionary rights required to be granted to patent owners under Article 28.1 of the TRIPS agreement. 28.1 is regard to the rights that are to be granted. So 55.2 was held to not fall within the ambit of reasonable restriction as given in Article 30, Your Lordship. That being the case, this was in 2000. Following this is when 107A was implemented to the 2002 amendment in India, Your Lordship. So, as per Indian law itself and the intent of the courts in interpreting in the Bay versus Union of India case, the goal has always been to make research on the drugs to have a generic variant ready, not to commercially manufacture and have the generic variant ready to sell it into the markets once it's ready, once the patent expires, Your Lordship. So, this being the case, Your Lordship, the goal of the interpretation of 107A has been that to research and prepare a generic variant before the patent expires. Not to commercially manufacture the generic variant and sell it right on the day the patent expires. The manufacturing process ought to start after the expiry of the patent because the right to manufacture is exclusively the patent owners.
How is it commercially manufactured?
They're commercially stockpiling the drugs, which means they are commercial.
Our assumption.
Sir, again, yes, Your Honor. I will be substantiating it with the prima facie infringement being shown.
Sorry to
Yes.
one more question. When you were reading the Canadian thing, it was the drug stock, right?
Indeed, yes, Your Honor.
Right. That is, my presumption is the active pharmaceutical ingredient, API,
Indeed, yes, Your Honor.
right? So if I ask you a question, the API is long expired. This is a formulation device. So, and you are giving a reference of the, is there anything further in the Canadian document that you are referring to? So, prima facie, you don't have any more protection on the active pharmaceutical. Okay, this is a device.
Sir.
What would be your?
Certainly, Your Honor. We are not contending or claiming the polar exemption at all for the use of the device. We are not concerned with the use of the API. They are free to manufacture the API in a commercial scale and package it in a different delivery device. What we are concerned with is the fact that they are infringing our delivery device patent alone. We are not at all concerned with the API here.
If you are allowing the drug to be put in another delivery, you said you can package it in another
Delivery device.
This device is nothing but the drug you're putting in this formulation.
Your Ladyship, this device has its own patent protection and it has its own excipient which is used to enhance the drug, and the same will be substantiated by my co-counsel with the validity of this patent. Currently, the presumption is that we have a valid patent for the packaging device. The fact that they are packaging the API, which we are not contesting. We are not contesting the use or manufacture or commercial.
My only question was, Canadian talks about API,
Certainly.
you are done with the patent protection for API. Is there any reference further to different dosage forms? That is my question.
Well, Your Ladyship, the reason we have cited this is because polar exemption has been claimed by the defendants in the instant case. Their claim is that they are using the formulation device as a part of the medical device, Your Ladyship. That being the case, commercially stockpiling the same would still fall under what was ruled by the WT dispute or as against them.
That may possibly be irrelevant because in the problem statement, what you say is, what has been discovered by your team, market intelligence team, is that the drug is being stocked.
Your Lordship, if I may.
Maybe they are wrong in claiming a polarization, but if the court were to look at it and say you don't even need to take that defense, because the allegation is only on the drug being stockpiled, and on the drug there is no subsisting patent.
Lordship, if I may read from the facts, paragraph 5.
6. Okay.
Paragraph 5. MedLife imported a significant quantity of the API and commenced manufacturing the finished formulation packaged in a delivery device similar to Pharmacos. That is our concern here, Your Lordship.
Right, but look at 6. What does your market intelligence team say?
The drug, which is the finalized product, Your Lordship, including the delivery device, that is our concern here.
That is, paragraph 6 doesn't say so.
Manufacturing the drug on a commercial. Your Lordship, they are importing the API. They have imported the API.
Correct.
And commenced manufacturing the finished formulation packaged in a delivery device. The formulation and delivery device is patent protected.
That is paragraph 5.
Certainly.
What have you found out?
That the
I
finished
don't know the number of the delivery devices
Your Lordship,
that
the
they have
drug
made or
comprises
imported.
the API, the formulation and the delivery device, Your Lordship. And the formulation and delivery
You are
device is
saying the
protected.
delivery device is also categorized as drug?
Not as a drug, but they are what they are manufacturing includes the delivery device and the finished formulation. The finished formulation and the delivery device are patent protected still.
Okay.
Much earlier. Your Lordship, I'd also like to seek an extension of time of this 5 minutes. Your Lordship, moving on to, if there's no other question, issue 1, can I move to the issue 2 here? Much earlier. With regards to issue 2, which is whether there's a prima facie case of infringement in the instant matter of fact. Your Lordship, I'd like to draw your attention to footnote 8, Your Lordship, of a complaint. This is the judgment of SNPC Machines versus Vishal Chowdhury. page number 221, Your Lordships. This judgment essentially, what they did in paragraph 35, the highlighted portion is that they have given a set of criteria which is to be taken into account for determining whether this prima facie infringement. I'd like to just read out the relevant criteria in short. First is whether the essential elements have been copied. Second, whether the difference is only in inessential elements. Third is an analysis of the infringement per se, of the accused device and the infringing device. Then there's the non-literal infringement, the doctrine of pith and marrow, and I'd also like to draw emphasis to point number 8, which is the doctrine of equivalence, Your Lordship. We are claiming infringement as currently we are not aware of the claims of the specific patent and the infringing device is not in our possession. We are not in a position to specifically construe the claims and make out a case of final infringement. So we can only claim preliminary infringement. And that being the case, we are claiming the doctrine of equivalence and doctrine of pith and marrow, Your Lordship. With regards to the doctrine of pith and marrow, that is the triple identity test which has to be satisfied. Firstly, the device should be performing substantially the same function in substantially the same method and obtain substantially the same result. In 2024, this test was changed to the Actavis test in the crystal Propolis Safex chemicals, where the result part has to be verified by a person ordinarily skilled in the art. And for doctrine of pith and marrow, there is the question of whether the substance of the patented invention is similar to that of the accused device. Our contention is that based on the facts, this is not what we have discovered from market intelligence, the facts themselves state they are packaging the finished formulation and the delivery device in a similar to what is pharmacos. So based on that, even if we assume it does not constitute a literal infringement, it would amount to infringement under the doctrine of equivalence and the principle of pith and marrow, Your Lordship. And additionally, Your Lordship, the fact that they have obtained a license, it shows their intent to manufacture the final product. With this, I would like to draw reference to footnote number 9 of our complaint, Your Lordship. Your Lordship, we are going to be praying for an injunction to be granted against further manufacture, use or sale of whatever drugs, whatever formulation and the delivery device which we still have patent protection for. And for granting of an interim injunction, a balance of convenience should lie in favor of us. In generally, in the prima facie stage, it will lie against the defendants. However, in this case, Your Lordship, ASI Co versus Satish Reddy, what the court held that the balance of convenience for the grant of interim injunction will lie in the favor of the plaintiffs because the defendants have not cleared the way before going ahead and obtaining a marketing license. So, the duty of the defendant before obtaining a marketing license is to ensure that they do not face any such infringement suits, and the fact that they have failed to do so clearly points to that the balance of convenience being in the favor of plaintiffs, Your Lordship. Also, the defendants have a duty upon them to approach the plaintiffs and ensure that there is no such infringement suit filed after they obtain a marketing license. And that being the case, the defendants have not failed to do that, which fails the clearing the way principle as held out in this case. They should have cleared the way before obtaining a license, remove all possible obstructions, including possibly approaching the plaintiffs for a licensing agreement or some sort of agreement. They have not done that in the instant case, so the balance of convenience will lie in the favor of plaintiffs, Your Lordship. And in addition, Your Lordship, in the ER script judgment itself, there was also essentials given for quaterment actions, which is that if we have an apprehension of danger, firstly because the balance of convenience lies in our favor, secondly the fact that they have obtained a manufacturing license, it is sufficient to amount to an apprehension of danger and amount to and would be a significant factor with a quaterment action being granted. If there are any other questions, the council would like to assist the court. Much ado. Certainly.
You can enlighten me on that. So you are saying that applying for manufacturing license insinuates towards.
Certainly, Your Ladyship, if I may.
Let me ask you one question. I just apply for a license, but I don't manufacture.
Your Ladyship, for applying for a manufacturing license, as per Drugs and Cosmetics Act, an inspection will be conducted either by the state authority or the central authority. In the instant case, it was the central authority. They need to enter the manufacturing facility, make sure they are in a position to manufacture whatever specified quantity of drugs, make sure the drug they are manufacturing is of the required quantity, and another essential is that it is not a patent protected drug. If it is a patent protected drug, they need to disclose all of its ingredients. Our contention is that the formulation is patent protected and they have obtained a license in some way or form. and if I may refer to a portion of this ER script judgment which states that obtaining license itself shows their intent to manufacture, and that is sufficient grounds for an injunction to be granted at this stage only.
My only question is applying for manufacturing license and assumption. So
If
they have visited the site.
Sir, yes,
Let me go a step further based on what you have given. So you're saying that they have inquired, they see a manufacturing facility. This is this generic company is also a big company. They have a facility. Your API is expired. Okay, they have. This is a question to you, a little bit technical. Okay, I have the parts of the device. Okay, may not be that. Maybe only for regulatory approval. I'm asking you.
Certainly. Your Worship, their intent might have been to start manufacturing at a different point of time. Maybe after the patent expires also. We are not contending the same. An affidavit from them in that regard that they are not in possession of a commercial
So
quantity.
your prayer is requesting them for an affidavit.
And an injunction, Your Ladyship, we require a proper seizure of the goods to ensure that they are not infringing right now, Your Lady. Even after the expiry of our patent, if at this point they are in possession of commercial.
Let us stick to this one. You said, this manufacturing license thing. So what would be your prayer? Are you asking for an affidavit is my question.
Your Ladyship, we are asking for an injunction and seizure of their goods. If Your Ladyship deems that their manufacturing is only after some certain point of time, to that regard, an affidavit would also be appreciated. Much obliged. If there's any other questions, I'd like to leave the podium for my co-counsel.
The counter seeks permission to approach the podium.
If it is of no inconvenience to your leadership, may I collectively address the bench of the court? Much appreciated. Your Lordship, if I may continue from where my co-counsel left, I will be dealing with issue 3. Issue 3 generally talks about if the formulation patent is an attempt to extend the monopoly rights and if it amounts to evergreening. And I'll also be dealing with the countersuit filed by the defendants on the validity of the formulation patent. Your Lordship, the counsel will be arguing this issue in 2 limbs. The first limb will be upon the validity of the patent since the Honorable Bench questioned it earlier. Your Lordship, to prove validity of a patent, the formulation patent in this particular instance, there are multiple elements that needs to be satisfied according to the patent law. Your Lordship, the counsel would like to substantiate on each and every ingredient of how this formulation patent satisfies everything. Your Lordship, to begin with, the requirement under section 1 clause J and 1 clause JA of the requirement of having a invention and inventive step, Your Lordship. Your Lordship, here the counsel would also like to present the facts, Your Lordship. In 2004, the APA was formulated and it had received the patent, Your Lordship, which had expired in 2024. And then later, the formulation patent was granted in 2006, Your Lordship, which is going to be expired in 2026. Your Lordship, in this particular instance, though the formulation patent had the API in it, the formulation patent was a completely new innovation. It was a completely new inventive device, Your Lordship, because in this particular formulation device, they had included the stability excipients and a delivery device, Your Lordship.
You formulated 21J or 21JA?
Your Lordship, the definition of invention falls under the section 21J, Your Lordship. And if I may read out the definition itself.
No, my question is your patent an invention or an inventive step? Which of these do you fall under? Your API could have been an invention.
Indeed, yes.
Your delivery device with the API and certain excipients, is that an inventive step or are you saying the delivery device itself is an invention?
Your Lordship, in this particular instance, the delivery device and the stability ingredient is an inventive step into formulating a completely new invention, Your Lordship. Your Lordship, it satisfies both the inventive step along with the invention, Your Lordship. Your Lordship, if I may read out the
There are
definition.
food drugs which are, using a device for delivery of the drug
Your Lordship,
before your invention. Were there no delivery devices for subcutaneous injection?
Your Lordship, but in this particular instance, the addition of the subcutaneous delivery device and the stability ingredient had resulted in a proper therapeutic efficacy, Your Lordship. And and that is the next level the council will be
Where
dealing
do you
with.
get
Your Lordship.
about this therapeutic utility?
Your Lordship, in the Moot proposition, paragraph number 10, Your Lordship, where it had stated that the new formulation patent solved critical issues of drug degradation and had also improved patient compliance, Your Lordship. Your Lordship, thereby, only because of the addition of the stability ingredient and the delivery device, we had solved critical issues such as drug degradation and improved patient compliance, Your Lordship. Your Lordship, it
What
is.
is an excipient?
Your Lordship, excipient is an element which is added to the API, Your Lordship, for multiple reasons, Your Lordship, and stability is one of the reasons to add an excipient.
It is basically to bind and,
Bind
put
the
it
API.
together so that it will be stable.
Indeed, yes.
Excipients are known in pharma industry for all drugs.
Indeed.
Right? Most of the excipients are common.
Indeed,
It
yes.
is only the levels of the mixture. So
Indeed.
essentially it is an admixture of known substances.
Your Lordship, in this particular instance, Your Lordship, it will not fall under the admixture because it also qualifies the synergistic test, Your Lordship. It also results in producing a higher efficacy here, Your Lordship. Your Lordship, in the council would like to state the case. Yes, Your Lordship. Your Lordship, in the case of Hoffman Roche vs. Cipla, where the Delhi High Court had clarified that it did not bar from having the improved stability and patient compliance to fall under the arena of enhanced efficacy, Your Lordship. Your Lordship, in this particular instance, the stability ingredient and the subsequent delivery device, Your Lordship, it resulted in proper stability of the API and also had improved the patient compliance, Your Lordship. Your Lordship, thereby it does fall under the arena of enhanced therapeutic efficacy, Your Lordship, and enhanced therapeutic efficacy as held in the case of Novartis AG versus Union of India. It is a ground to it is one of the element to qualify as a valid patent, Your Lordship, and that is also an argument that the council would like to present to prove that that Pharmaco has not established evergreening, Your Lordship.
In paragraph 10, the problem statement, there is nothing about the delivery device. Correct? So your claim of invention again is on the API principle. Maybe with the excipients, according to you, it is leading to lesser drug degradation. But there is nothing on the delivery device itself.
Your Lordship, the delivery device is also an important part of the formulation patent itself to result in improved patient compliance, Your Lordship. Your Lordship,
What do you mean by improved patient compliance?
Your Lordship, in this particular instance, Your Lordship, it is well understood that the delivery device could have been an injection, it could have been a patch, it could have been anything, Your Lordship. But then the only because of the delivery device was the API more useful and more and it had solved multiple critical issues, Your Lordship. Your Lordship, the council would also like to guide the bench to the timeline of this patent, Your Lordship, where in 2004 the API was granted, Your Lordship, and in 2006 when the formulation patent was submitted in the patents office. In this 1.5 year period, Your Lordship, proper research and developments were conducted, and only after that, where due to the advancement in science and technology, Your Lordship, the delivery device, which was important for the improvement of the API, and because of the excipients added to the API, Your Lordship, it was able to attain a new patent itself, Your Lordship. Thereby, Your Lordship, it is understood that the delivery device might be an obvious step, Your Lordship. But then in this particular instance, Your Lordship, in that particular period, no one had applied for a patent, Your Lordship. And anyone could have added a stability ingredient and delivery device, Your Lordship. But in this particular instance, since we also do not know the particular claims of what the stability device or what kind of a delivery device was used, Your Lordship, the inventive step here was that the delivery device and the excipient which was used for stability was the inventive step which resulted in better patient compliance and better and avoid drug degradation, Your Lordship. If Your Lordship is convinced, may I please proceed? Much obliged, Your Lordship. Your Lordship, to continue with the other elements that it has to satisfy in order to have a valid patent, Your Lordship. Your Lordship, the next element, since the council had established that it had inventive step and it qualifies under section 2 clause 1J and JA, Your Lordship, the council would like to move to the element of novelty and industrial application, Your Lordship. Your Lordship, in this particular instance, the novelty was that with the API, the delivery device and the stability ingredient was added, and it helped in the formulation of a new complete device, Your Lordship, which not only helped in the working, but it had also increased the patient compliance and resulted in enhanced efficacy, Your Lordship. Your Lordship, here the question of industrial application does not even arise, Your Lordship, because my learned opposite councils and the MedLife Co, they want to go ahead and produce and manufacture it because it has such a good industrial application, Your Lordship. Thereby, it satisfies the element of industrial application and novelty as well. And Your Lordship, in this particular instance, the council would also like to rely that the burden of proving the invalidity always lies on the defendants in this particular case, Your Lordship, and as held in the case of Vishwanath Prasad's Radheshram versus Hindustan Metals, Your Lordship, it had held that once a patent is granted, and the initial presumption of validity, especially when the patent was available in the public forum for about 19 years now, and there are only 4 more months, Your Lordship, and now challenging it, the plaintiff in this matter will obviously have a presumption of validity, Your Lordship, which is why we had argued the Bolar exceptions first and then a prima facie, and now also substantiating on the patent validity, Your Lordship. Your Lordship, and along with that, we also have the case of Bajaj Automobile versus TVS, Your Lordship, which held that if the patent is in the market for more than 5 years, the presumption of the validity of the patent will obviously go to the plaintiff, Your Lordship. And now challenging it only when there is 4 months left, Your Lordship, it only creates an assumption that they are going ahead with this countersuit because we had approached them for patent infringement, Your Lordship.
But is the law not in favor of saying that the courts have to decide whether it is patentable or not once the issue is raised before the court?
Indeed, yes, Your Lordship. And Your
there's
Lordship,
no limitation on that, so whether it is just on the end of the just 1 month before the expiry, or even if it's in the first year of the thing, it doesn't make a difference as far as the court is concerned.
indeed, yes, Your Lordship, but in this, there is also an presumption of innocence in favor of the plaintiff is what the council like to establish, Your Lordship. Much obliged, Your Lordship. Your Lordship, now the council would like to move on to the concept of evergreening, which has been accused, Your Lordship. Your Lordship, here the concept of evergreening is put into the section 3 clause D, Your Lordship. Your Lordship, here the concept of evergreening is established that the mere new form of a known substance, unless the applicant demonstrates enhanced efficacy, Your Lordship. This is made sure because the intent of the legislature for this particular section is that there is no monopoly and there is no unfair patent granted to only one company, and there is no unfair monopoly. Your Lordship, in this particular case, Your Lordship, the API was granted in 2004, and then immediately in 1.5 years, Your Lordship, the formulation patent, due to research and science and growth of technology, we had filed for the formulation patent, Your Lordship. And the difference between both of these patents were nearly 1.5 years, Your Lordship. Your Lordship, if the intent of Pharmaco was to unfairly extend the patent rights, the formulation patent could have been filed long after the compound patent, Your Lordship.
Can also we presume that you come up with the second patent so quickly that there was really nothing, to be invented. You just waited for a little bit of time and then added some excipients and put it in a device, which is essentially a method of treatment.
Your Lordship, the excipients and the delivery device itself adds to an inventive step, Your Lordship, since it has also proved to have enhanced efficacy, which the council will be substantiating, Your Lordship. Your Lordship, the API was a valid patent and it had expired, Your Lordship. And now the formulation patent here is again a valid patent, since it not only was any stability ingredient or any delivery device, Your Lordship, it had resulted in proper higher efficacy and also qualified the synergy doctrine, Your Lordship. Thereby, Your Lordship, since the result of the stability ingredient and the delivery device here was more than just an addition, which is why we did not go for a patent of addition, Your Lordship, but we filed a new patent, Your Lordship. And it is very common in the pharmaceutical industry to have a compound patent and later go for a formulation patent, Your Lordship. Your Lordship, the difference between compound patent and formulation patent itself is that in the formulation patent, the necessary excipients and the delivery device in a few cases are added, Your Lordship. Thereby, Your Lordship, the argument for argument of purpose, Your Lordship, the difference of going for a patent of addition will also not be applicable here, Your Lordship, because it was not just an upgrade, Your Lordship, but it was a different innovative step and a new, completely new product, Your Lordship.
So when you obtain the patent for your API, what was the claim for the patent? Would you have shown that the API is good enough to treat a particular disease?
Indeed, yes.
So the question of stability would have been covered with that?
Indeed, yes, Your Lordship. Your Lordship, in the 1 year gap, Your Lordship, there might have been stability issues, Your Lordship, which is why after proper research, better excipients were added in order to control the drug degradation, Your Lordship.
Isn't that something a person skilled in the art could have come up with? No, it's only known excipients. You will have to, probably iterate on the percentages of the excipients. The API is known, the compound is known. So therefore, a person skilled in the art could have come up with it.
Indeed not, Your Lordship, because it is not the compound, the formulation of the formulation patent is not as obvious as any person who is skilled in art could be, was able to figure it out, Your Lordship. The particular
How do you
excipient.
know within 1.5 years you come up with something?
Your Lordship, that is because the Pharmaco was the inventor of the API and still continued to have proper research and technology in order to come up with a more inventive and come up with a new device which is better than this, Your Lordship.
Where in the problem statement do you get the 1.5 year that you're getting?
Your Lordship, in the paragraph 3A, where the compound patent was granted in 2004, Your Lordship, and in B, the formulation patent, though granted in 2010, it expires in 2026, Your Lordship. So it is understood that we had submitted it in 2006 itself because the 20 years period of expiration. Your Lordship,
That essentially means that, as said, you have filed it quite in a little period of time. I have a quick question for you. A quick question, because I think we are running short of time. Now that you have filed a formulation, why should I not assume that you are in the process of evergreening, coming up with, you had a monopoly for 20 years on the API, okay? And now you have come up with a device for 2026. You may also be working on, as I said, another set of excipients. So why should you get the benefit alone?
Your Lordship.
Why is it not evergreening? And you said synergism.
Yes.
How is synergism applicable for formulation?
Much obliged, Your Lordship. Your Lordship, the question asked, the council will be answering in 2 years. With respect to why we will not be coming up with a future patent by adding some other excipient, Your Lordship. Your Lordship, in this particular instance, the patent which was granted in 2006, Your Lordship, we had proved novelty, we had proved inventive step, and a delivery device which had improved the efficacy, Your Lordship. Your Lordship, only after satisfying all these ingredients did we get the patent for formulation, Your Lordship. In this particular, and there is, Your Lordship, this itself is a complete patent, Your Lordship. There is, even if there was anyone else to come up with a better excipient, Your Lordship, and even come up with a different delivery device, the council doubts if there would be any kind of novelty. If there is novelty and there was inventive step, Your Lordship, it could be granted as a new patent. But in this particular instance, the council had to substantiate that when the formulation patent was applied, Your Lordship, we had proved all the elements and got the patent. And even in the future, only if there is novelty and inventive step will we be applying for a different patent, Your Lordship. Lordship, the council believes that only because we have satisfied all the ingredients and substantiated on the efficacy part as well, where we granted the formulation patent. The council does not have, and the Pharmaco company is not going to apply for a different patent for evergreening if it does not result in proper enhanced efficacy, Your Lordship. Only if, according to section 3 clause E, the patent, the additions for from the compound patent is allowed only when there is enhanced therapeutic efficacy, Your Lordship. If there is no therapeutic efficacy, even in future we will not be applying for any patent, Your Lordship. And for the second limb of my of the question, Your Lordship, which dealt with the doctrine of synergy, the council would like to substantiate that this particular formulation patent, the council seeks 2 minutes. Your Lordship, the council would like to substantiate that this particular formulation patent will also not fall under section 3 clause C, which deals with admixture, Your Lordship. And And to substantiate that, the council brings in the doctrine of synergy, where your lordship in simple terms, synergy, the doctrine of synergy explains that when there is 1 plus 1 and if the result is 3 and not 2, there is a higher effect, your lordship. Your lordship, in this particular condition, your lordship, there was a stability ingredient and there was a delivery device. Your lordship, in every drug, as your lordship previously stated, most of the APIs will require a stability device and a delivery device, your lordship. Or a delivery device is not necessary. But only in this particular API and only in this formulation patent, your lordship, did it actually result in higher patient compliance and also enhance the stability, your lordship. Your lordship, there are multiple APIs which itself is stable in nature, your lordship. And there are multiple APIs which do not need a stability experience. Your lordship, because of the addition of, because of the stability ingredient and the delivery device, it had resulted in better patient compliance as well. Thereby, your lordship, the result of the mixture of the result of the new formulation patent had resulted in better efficacy, your lordship, and it was a higher effect, thereby qualifying the synergy test, your lordship.
Synergy, explain to me, if there is an API and there is some other, compound or formulation that you are adding on, the concept of synergy, at least in my understanding, would come. If it is an excipient which is actually not going to react with the API, where is the question of synergy? It is only a binding agent, right? So what synergizes with what? Here you had 1 plus 0, which gives 1, right? Because it's only a binding agent. There was no need for a reaction with the excipient and the...
It had resulted in not only stabilizing the drug, but also improving the patient, had resulted in not only stabilizing the drug, but also improving the patient compliance.
Sorry. So, just to clarify, my own, in my mind, whether I have understood things correctly, the concept of synergy, as I said once again, is that there is a reaction between two different, compounds or, chemicals. Now, when you added an excipient, your basis for adding that was to get the stability or, get the drug in a form that it can result in delivery, right?
Indeed.
So, synergy is where you add 1 plus 1 and you get a surprising result which is 3, right? When you added it for the purpose of stability, what was the surprise?
Your lordship, the surprise in this particular case was that it improved patient compliance and drug degradation, your lordship.
Actually, what you said is right. Synergy is they both have to give additional. Synergistic is what? A plus B should give more than what A plus B would deliver.
Much obliged, your lordship. The council is with the bench on the meaning of synergy, your lordship. The council would just like to substantiate that in this particular instance, adding the stability excipient along with the API, which itself is a patent protected product, along with the delivery device, resulted in not only the working of the API, your lordship, but also in the process of stopping the drug degradation and better patient compliance. So it is well understood that the excipient was for stability, and that lordship, as lordship stated, thereby it did its work of creating stability, and there was no surprise. This is the bench's question.
No difficulty there because the problem statement didn't, I think, say anything on synergy. You came up with synergy, therefore I had to ask.
Much obliged, your lordship. Your lordship, the concept of synergy was brought in so that the council had to substantiate that it not only falls under section 3 clause D, but it will also not fall under section 3 clause E, your lordship. Your lordship, the council would like to conclude the arguments by wrapping up. Your lordship, the council would also like to bring to the notice that a settlement agreement which was executed in a different country by the defendants, your lordship. Your lordship, the council is well aware that the patent law is territorial in nature, thereby it is upon the bench to take it into persuasion, your lordship. But in this particular instance, your lordship, them getting into a settlement agreement, they have itself accepted that this particular patent is valid. Now Now challenging us for patent infringement in that particular instance does not seem to be valid, Your Lordship. In Your Lordship, it was also held in the case of Hoffman Roche versus Cipla, where it had accepted that the international settlement agreements can be brought into reference in this court, Your Lordship. Your Lordship, and maybe if no further assistance, the council like to move on to the plea. Wherefore, in the lights of issues raised, arguments advanced, and authorities cited, it is most humbly paid before this honorable court that it may be pleased to declare that the Bolar exemptions cannot be invoked and for non-commercial stockpiling of patent protection formulation, and grant an immediate and temporary injunction against MedLife, restraining them from manufacturing, using, selling, and offering for sale the patented formulation, and exporting any such infringing product until the matter is fully adjudicated, and that there is a prima facie case of infringement, an order is issued for infringing the goods, and that the formulation patent satisfies the essentials of valid patent, and it is not an attempt of evergreening, and thereby dismiss the counterclaim, Your Lordship, and pass any other order that this honorable court may deem fit in the proper circumstances of this case. And for this act of kindness, the counsels for the plaintiffs will be duty bound and follow up.
Anyway, it will only be valid for 4 months. Any
Indeed.
order that is granted. Thank you.
Much obliged, Your Lordship. It was a honor pleading before this bench.
The council seeks permission to address the bench presentively at your lordship. Much obliged. Your lordship, this is council number 1 representing the defendants. Council number 1 will be dealing with issue 1 and 2 and will be taking 23 minutes of court's valuable time. And council number 2 will be dealing with issue 3 and will be taking 20 minutes of the court's valuable time. And 2 minutes shall be reserved for surrogate. Your lordships, before Moot, if your lordships are well versed with the facts, shall the council move to the arguments?
Why don't you go over
Definitely. Your Lordship, I'll quickly summarize the facts of the case. That is, the whole case is dependent on 2 patents. That is, the first patent that was granted in 2004 for a drug known as glucobol, and the first patent was a compound patent for the API. And the second patent that we are talking about was granted in 2010, and the said patent is for the said patent is formulation patent and is set to expire in April 2026. Your Lordship. Post the expiry of the first patent, that is the API patent, MedLife, that is the defendant, started manufacturing the finished formulation in a similar delivery device, and post which the plaintiffs had filed an infringement suit, Your Lordship. After which, the defendants had also filed a counterclaim questioning the validity of the patent itself, Your Lordship. Hence the said case before the Honorable Lordship. Your Lordship, before moving into the arguments, the council would like to clear one thing, that we will be arguing that there is no prima facie case in the issue 2, and the validity of the patent also will be argued in issue 3. As long as issue 1 pertains, the arguments are majorly that in arguendo, even if this court holds that the patent is valid, in arguendo, even if that is happening, the actions of the defendants are still protected under the Bolar exemption, that is 107A, meaning that there has not been an infringement. If your lordships are convinced, the council would like to move on to issue 2 first and then come back to issue 1 for the line of the arguments. Your
and
lordship.
you're going to address both 1 and 2.
Yes. Your lordship, issue 2 is pertinent to whether they have established a prima facie case or not. Your lordship, just to start off, at a prima facie stage, more than the evidence, it is whether, by the looks of it, do they have they established a case or not. Your lordship, before moving to my submissions per se, I would like to point out that all of their arguments have been based on the fact that their private market intelligence team have found commercial stockpiling. They have not produced any proof or affidavit on the same. Hence, the same is not binding on the court as of now, Your Lordship, unless they provide proofs of the same. Your Lordship, moving forward.
Isn't that their entire case? What is the, I am assuming, based on all the problem statement says, that it is there a case that the market intelligence team has found this? That means that there is a pleading to that effect in their suit, right, in their claim,
Indeed.
right? Therefore, I mean, where is the requirement of an affidavit? It is there in the claim, one.
Indeed.
I don't know what annexes are there for the claim, but we
There has
probably presume that the report is there. But in any event, there is a pleading.
Indeed, Your Worship. The counsel was just stressing on the fact that there has to be some proof on the allegation that's been
But you
made.
said we don't need to look at everything.
No.
This data.
Exactly, Your Lordship. I will be arguing on the validity aspect of it further in the line of argument. Your Lordship, to start off, Your Lordships may kindly refer to section 13 clause 4 of the Patents Act, which clearly lays down that the grant of patent shall not be deemed to warrant its validity. Now, Your Lordships, if Your Lordships may please refer to page 20 of the compendium, Your Lordship, which is giving a case that is the 10XC Wireless Incorporation and another versus Morby Antenna Technologies, Your Lordship. If Your Lordships may. If Your Lordships are with me.
Yes.
Page 20, line 14. The same has been highlighted for you. Page 20, line 14. Your Lordship, at prima facie stage, the question of validity of a patent is not free from doubt. In the same page, Your Lordship, if you refer to line 8, it is also given that the revocation of patent can be sought under section 64 of Patents Act by a defendant by a counterclaim. The same has been done in this case. Moving forward, Your Lordship.
See, statutorily, as brother had pointed out, you probably have a right to question the validity.
Indeed, Your Lordship.
But there are two factors that you need to explain.
Indeed.
One is that you have come so late in the day.
Indeed, Your Lordship.
The drug was known, the compound was known in 2004 or whenever the
Indeed.
The formulation was known probably a year and a half or 2 years later.
Indeed.
Now you're coming at a stage where it is being worked for about 20 years.
Indeed.
You're in the same industry, so it is quite obvious that it is not as if you are unaware of it.
Indeed.
Right? One. So that is one aspect that needs to be explained. So is this just an afterthought or a device that you are employing to push things for 4 more months and then be done with it? A. And B, with respect to the agreement that you entered into in respect of this very same patent in some other country, where at least prima facie, if you admit that yes, there is such an agreement, which is what the problem statement seems to indicate, then you have admitted to the validity of the patent.
Your Lordship, if I may answer the same.
You have to.
Indeed, Your Lordship. Your Lordship, I would firstly take
Just adding on to what
Indeed, Your Lordship.
Madras said. You started manufacturing in 24. But you knew what the formulation patent was.
Indeed, Your Lordship.
But you challenged that only a year later when after they started actually.
Definitely. I will be answering. Your Lordship, I will answer the last question that Your Lordship asked, and then other questions I'll be answering the due personal arguments. I have in the arguments I'll be answering. Your Lordship, as far as the settlement agreement goes, first of all, Your Lordship, the settlement agreement that we are talking about is part of a parallel litigation. Nowhere in the proposition is it stated that the facts of that case is also the same. And this settlement in a parallel litigation happened in United Kingdom, Your Lordship. The same is not applicable to this case, Your Lordship. Now, moving forward in the same thing, it is also talking.
Is it not between the same parties?
It is between the same parties.
Forget the statutory framework on what is a valid patent, how it can be challenged.
Indeed.
So, query parties, right? You have come to some understanding with respect to the same compound or formulation, right? So does that not mean that you, as a party, have agreed to something? Forget the law. Speak on the facts.
Your Lordship, even speaking on the facts, it is parallel litigation. That's what I was stressing on. Since it's a parallel litigation, the facts of the case itself could have been different there. It is not stated in the proposition. The proposition is still silent on that. And the subject of matter of the agreements or the settlements could also have been different. Until that is stated, we cannot come to a reasonable assumption that this same subject matter of this case has been agreed to in United Kingdom. That has not been stated anywhere. Hence, the same is not admissible in this case, Your Lordship. Your Lordship, if I may move on with my arguments, I would in due course answer all the other questions. Your Lordships, if you may please refer to page 22. of the compendium, Your Lordship. Your Lordship, if Your Lordship is with me. Your Lordship, prima facie proof of infringement is different from prima facie proof of validity. As given under NRDC versus DCM Limited, the plaintiff must first establish such facts as will satisfy the court that there is a strong prima facie reason for acting on the supposition that the patent is valid. It is agreed that they have a granted patent, but they have not prima facie proved that they have a valid patent. They have always gone ahead with the assumption that they have a granted patent and hence it is valid. However, that is not the actual question of law, Your Lordship. Your Lordship, if you may please refer to para 87 that's mentioned in the same page, Your Lordship. In that particular case, since they had failed to establish prima facie case, they had failed to establish the prima facie case as there was also a credible challenge to the patent, the validity of the patent itself from the defendants. That's exactly what is happening here, Your Lordship. We have raised a counterclaim and we are also challenging the validity itself. Hence, the onus was them, at least prima facie, to prove that the patent itself was valid. The same has not been done in this case, Your Lordship. Now, Your Lordship.
There is one patent which is in respect to the compound which has worked itself out, which obviously you have not challenged.
No, definitely.
So, when it comes to prima facie validity of the patent,
Indeed.
where do you say that they are falling short in showing that it is valid?
Indeed.
Two aspects. One is their argument that there are excipients which add stability and increased consumer preference or that is one part of it. The other is that the presumption under law where a patent has been worked for 5 years or 7 years as the case may be,
Your Lordship.
then you have to presume validity. Right? Grant does not show validity is one.
Yes.
Presumption on validity because of passage of time as laid down by courts
Indeed, Your
is
Lordship.
another.
I will be citing the same case they used for the driving home the same point, Your Lordship, because the same case itself.
Not driving on the same point.
No, I mean, my point. Your Lordship, first of all, just by the prima facie looks of it, as they had also already agreed, the second patent only was applied in 2006. There is a 2 years gap. Now, with pertaining to the validity of the same, my co-counsel will be arguing. Now, if my co-counsel is proving that there is no validity, the 2-year gap has to be explained by them, citing. So, that is what we are raising at the prima facie stage. That is, there is a 2 years gap, and we have already challenged the validity. Now, it's on them to at least prima facie. Once we prove that the patent is invalid, they'll have to explain the evergreen there. So, hence, there is a prima facie. But just by the looks of it, there is a patent evergreen because there is a clear gap between 2004 and 2006, and they themselves has agreed that API is a major component of the second patent. Your Lordships.
But how do you make the argument that if it was going to be for the purpose of evergreening, why would you make an application for a grant of patent within such a short period of time? See, I can understand that it is run for 10 years. You want to have the patent valid for not 20 but 30 years. Therefore, after 10 years, you come up with this. Then, on the face of it, there could be a presumption of evergreening. But if you've done it so quickly, if someone has done it so quickly, then and it's going to give them an advantage of just 2 more years.
Your Lordship.
Why would you
Your
say it is
Lordship,
evergreen?
this particular issue will be exclusively dealt with by my co-counsel. Evergreening, he's dealing with that. I hope your Lordship's questions will be answered then. Your Lordships, if I may move forward, TVS Motors versus Bajaj Auto Limited. This is the same case they have also mentioned, Your Lordship. If Your Lordships may please refer to page number 23, Your Lordship, of the company. They have clearly set out certain points. I will read it out for the Lordships. First of all, the validity of the patent can be challenged in a suit, as I have already also submitted. Second one being, the grant of an interim injunction in a patent matter, the prima facie validity of the patent should be shown, and also the prima facie infringement should be proved apart from the availability of balance of convenience and irreparable law. Now going on to the balance of convenience and irreparable laws, Your Lordship. This majorly arises from American Cyanamide versus Ethigan. The same has been enumerated in the compendium as well, page 21, if Your Lordship may refer to. It's an international case, but the same has been accepted by Indian courts. Your Lordship, it is clearly laid down on that prima facie is not the only thing. We'll also have to look at balance of convenience and irreparable loss. This case, however, Your Lordship, they do not have an irreparable loss. I'll tell you how, Your Lordships. First of all, in this case, it was held that if damages to be awarded at trial can adequately compensate the plaintiff and the defendant could pay them, then the injunction can be refused. In this case, as the case also suggests, Your Lordship, there is no irreparable loss. Even all the losses they are not in the market in Equatorial or Costa Rica, and they don't have a patent there. So we are not violating anything there. So there's no irreparable loss for them. Even if this court goes ahead and finds out that they have to be compensated, the same can be done in trial.
Their case, as I understand it, is that there is commercial stockpiling.
This will be answered in.
Let me complete.
Yeah.
I haven't come to the question. Right? So, because your submission is that they are not operating in these two countries, or at least they don't have a patent in those countries. Therefore, they will not be affected by my selling the product in those two countries. Therefore, that's not your patent.
That's not.
Okay, tell me more.
It's my selling will only start after the patent has expired. Whatever I have, this I will be elaborately covering under issue 1. Your Lordship, I have not exported the products right now for sale there. No, that is not what we have done. Whatever we exported is only for the regulatory authorities, which I will be proving in issue 1, Your Lordship. Hence, right now there is no irreparable loss. We are not selling it there or here. We are just exporting it for the regulatory purposes. Hence, there is no irreparable loss, Your Lordship.
Let's come to that. If your argument is that I am not selling, I will manufacture and keep it with me. And the moment the patent expires, I will flood the market with what I have manufactured. Will that not be an issue? My question is on the basis of these assumptions.
Yeah.
Will it then not be an issue where there will be an irreparable loss to them?
Your Lordships, since you're
Which is what they had argued in respect of, what 55(2)
yes.
of the Canadian law
Indian
as
law,
considered by the, the WTO had ruled on, and there is absence, at least in that case, there was a provision which the courts had indicated may not be appreciable, right? Insofar as our act is concerned, the statute is concerned, such a provision is not even there, that protection is also not there.
Indeed.
Therefore, there is a presumption that you cannot stockpile.
Indeed.
Because
Indeed.
you don't want a situation where all of a sudden the market is flooded with a generic product which will affect them.
Indeed.
Right?
Indeed.
So therefore, one of the two things, either your argument is that I am manufacturing to export there where they don't have a patent, right? Or that I am keeping it here, I will not sell it until the patent expires.
It's none of the above, Your Lordship. Your Lordships, if I may, I had just have one more submission to make under prima facie case, then I'll be going on to issue 1.
No, complete this irreparable loss argument.
Indeed. Your Lordship, to say that they don't have an irreparable loss, I technically would have to prove what I'm exactly doing, and that I'll be doing in the issue 1 as well, Your Lordship. Just one more submission in this issue, and then I'll be taking on all your questions, Your Lordship. That will be dealt with in issue 1, I assure you that. Your Lordship, the last thing being, if you may please refer to page 28, that is para 149. This case is Novo Nordisk versus Dr. Reddy's Lab. Your Lordship, this is a very recent case as well. In this particular case, Your Lordship, the defendants had given an undertaking stating that we will not be selling the products in India. In this particular case also, and this undertaking was not given prior to the case, it was given during the due course of the arguments. We can do the same thing, Your Lordship. We are not intending to sell in Indus land when their patent subsists. And this case also went on to hold that once such an undertaking is given, the interest stands balanced, meaning that the balance of convenience is also balanced. Now,
But does this case consider the aspect of commercial stock?
now I'll answer all your questions there, Your Lordship. Definitely, Your Lordship. Your Lordship, since they have already explained section 48 and 107, I'm not going into the little definitions of the same. However, I'll be citing bias cooperation. Bias cooperation was union, first of all, Your Lordship. First of all, just to start, exporters within the section is already given in bias cooperation. The same has been enumerated in page 2, para 92 as well. Your Lordships, if Your Lordships may please refer to page 3, that is para 93. The court has clearly stated that the question on an injury caused due to the commercial sale will not arise when the purpose of such export is solely research and development and providing we as defendants here are exporting solely for giving information to the regulatory authorities. I will be arguing on this further, Your Lordship. If Your Lordship may further refer to page 4, that is para 5 of buyer judgment itself. The quantity used, not the place of research and development, is the deciding factor. But what actually is the deciding factor is the purpose entirely. If the purpose is giving information, the quantity is not an issue, Your Lordship. Furthermore, Your Lordship, there is no ironclad rule on the same, Your Lordship. That is what is the exact quantity. If Your Lordships may allow me to tender I had missed that page in the company, so I could please tender this. Copy had been provided to opponents as well. Now, Your Lordships, since there is no ironclad rule, how do we determine what is the exact quantity, Your Lordship? Two things I will be citing, Your Lordship. First thing, the Canada case they have also cited. Now, while we are determining the quantity, are we just looking at a lab samples? When we export something, is it just a lab sample for the regulatory authorities? It is indeed not, Your Lordship. When we talk about just the lab samples, the actual ambit of the quantity itself is reduced. In this particular aspect, Your Lordship, if Your Lordship can please read what is written in italics in that page I've tendered right now. I'll just read for Your Lordship, that is. Carrying out chemical and biological synthetic processes suitable for making, disposal or keeping of active substances, including the manufacture or import of batches in quantities sufficient to provide material for preparing investigative batches of the medical product and to validate the process to satisfaction of the competent authority. Now, Your Lordship, investigative batches of the medical product, this is something I have to stress on. Your Lordships, if Your Lordships may please refer to page 8 of the compendium also, Your Lordship. Page 8, we have provided WHO Technical Report Series number 929 of 2005, which is the guidelines for sampling of pharmaceutical products. Your Lordship, under these guidelines, Your Lordship, as I've already asserted, it's not a lab quantities. We are mandated to actually send significant quantities so that the tests abroad can be done properly, Your Lordships. Your Lordships, if I may please direct your attention to point 3 under page 8, that is regulatory issue, Your Lordship. It is clearly stated that additional samples are to be provided so that the regulatory requirements are met. Moving forward, Your Lordship.
Where do you get that it should be significantly high quantities?
Significantly high quantities, I'll be right next point, Your Lordship. Now, Your Lordship, what are the inspections that I'm talking about? Two things are there. First of all, it's a pharmaceutical inspection, and then the next one is a surveillance program, Your Lordship. Now, there are other factors such as when they are sampling, they have to look at uniformity of the samples as well. Now, uniformity of the samples, if you look at it, it's not taken from the same containers, Your Lordship. Just to ensure the uniformity of the drugs that are provided while you're sampling, it can be taken from more than one containers. Just to ensure.
It will be containers. It can be just small boxes of the.
Your Lordship, however, that's not what the WHC actually says.
Where does it say containers?
Yeah, that's why I did not mark the same. Sorry. Your Lordships, another point is, as far as surveillance programs are concerned, the extent to which the quality has been asserted prior to registration is also another matter we have to look into. The next one, number of products imported from abroad is another determining factor that we have to look at when we are doing the surveillance program. Hence, Your Lordship, we as the defendants here have, first of all, as Your Lordships have mentioned, and they are also cited ER squibs, which is a case that talks about the flooding of the market. Your Lordships, we do realize that under section 48, if we had made the products, that itself will constitute a violation. However, it is the same thing that is provided as an exception under 107. That is, if the making was solely to give the information to the regulatory authorities, the making is not violation. Now, Your Lordship, they have asked us for an undertaking. So even if you are talking about the guidelines in the bias case, Your Lordship, all these guidelines are not a prerequisite for us. We were under no obligation to give all those specifications to them. The guidelines only comes into play when the inquiry is being done, Your Lordship. And the same can be provided if this case is accepted by the Lordship. The same can be provided at the later stage. This is the first hearing, Your Lordship. And since it's the first stage of hearing, Your Lordship, the same can be provided later. That is the particulars with regard to what exactly is the regulatory
The concept of clearing the way.
Your Lordships.
You had the negotiations with them for license.
Indeed, Your Lordship.
Why did you do that?
your lordships, the negotiations, if you look at para 11, was only for selling the same in Indus land. We very well knew that we had a valid API patent in Indus land, hence, if we had to sell there, we had to take their license. That is the
For API.
no, not the APIs, constantly insurance, the said formulation technology. If we had to manufacture and sell it, we had to take their permission. And also, Your Lordship, the date of which this negotiation happened is also silent in the proposition, hence I'm not assuming the date. Either way, Your Lordships, the licensing negotiation was solely for selling in Indus land. The licensing negotiation did not result in the license clearly, hence we did not sell it in Indus land. Now, when you are talking about clearing the way, Your Lordships, if Your Lordships may please refer to page 29 of the compendium. Your Lordships, it is again the same case, that is the Novo Nordisk case. There is no obligation to only utilize the pre or post grant opposition mechanism, Your Lordship. Neither does a patent benefit from the presumption of validity if it is challenged in course of an infringement suit. However, if the defendant is aware that there may be a possible challenge to its product, but still chooses to release the drug without first invoking revocation proceedings or attempt to negotiate that, it is a relevant factor. Accepted, Your Lordship. Now, if we were trying to sell this in Indus land, then we would have to do the clearing of the way, that is getting into a negotiation with them, making sure that they are okay with it, and then moving forward. The same has been done. The negotiation has happened in that aspect. Now, however, this exporting part is clearly covered under 107A. That means that we are already doing a legal thing for which we do not need their permission or a license. That is the whole reason of 107A, Your Lordships. If even after invoking 107A, if I had to go to them every day to take a license, to do a mere legal act, which is completely in my power to do, that would clearly defeat the purpose of 107A.
What you're saying is clearing of the way is required only if you propose to sell it during the validity
Exactly.
of the patent.
That is what we exactly in Your Lordship. That is exactly what we did. And finally, Your Lordship, this is the last submission. I hope I've been clear on all my other submissions. Final submission, Your Lordship, they are also contended that the marketing license, your ladyship have, if your ladyship and lordship, if I may just get 2 minutes extension. Your Lordship, with regard to the marketing license, that is, they had contended that we had applied for a marketing license, and that itself drives our intent. Your ladyship, and lordships, if you may please refer to page 18 of the compendium, which is giving a case that is Burkhardt versus Hetero Drugs. Your lordships, in this particular case also, it was a similar circumstance. The plaintiffs had challenged the defendants because they had obtained a manufacturing license and they had started manufacturing. In this case, the court had looked into the matter and held that now applying for a manufacturing license itself is not illegal. Just applying for the same is not illegal. Now, if they wanted to question the validity of the manufacturing license, your lordships and ladyship, the CDSCO also had to be a suit to this party to the suit, because they are the ones who gave us the license. Now, just applying for the license is nowhere illegal. Now, if they had a problem with the validity of the license, they had to challenge that separately. It is not that you're saying that, oh, there is a commercial intent just because you have applied for a marketing license. The same has been held in this case as well, Your Lordship.
Why did you apply for it? Why did you apply?
So that see, your ladyship, the whole purpose of 107A is that we can use the section and do away with all the regulatory proceedings, so that once the patent is expired, we can start manufacturing the good, whatever we want to sell them. Now, we have applied for a manufacturing license along with meeting the regulatory requirements. We are not going to start flooding the market as soon as the patent is expired, because we are not even producing the goods right now. The only things that we are producing is whatever we have to sell to the regulatory authorities. That is why we have applied for the manufacturing license itself. If your lordships are convinced with my arguments, the council would like to conclude now. However, if your lordships have any questions, the council will be obliged to answer. It was a pleasure arguing in front of you, your lordships. With that, I conclude my arguments. Much obliged. Counter 6 commercial pricing before.
counsel number 2 appearing on behalf of the defendant representing the Madras. Will be dealing with the third issue and will be speaking for 20 minutes, Your Lordships. And the issue 3 before the Honorable Court, Your Lordships, says whether the formulation patent is an attempt to extend monopoly rights beyond the original compound patent amounting to patent awakening, Your Lordships. And with regards to the same, my first submission being Section 3 Clause D, Your Lordships, is a substantive threshold barring the impugned formulation patent in this case, Your Lordships. The defendant submits that formulation patent does not qualify as an invention under Section 2 Clause 1 Clause J of the Patents Act, which defines what an invention is, Your Lordships, and is squarely kicked by Section 3 Clause D also, Your Lordships, wherein it states mere discovery of a new form of a known substance which does not result in the enhancement of the known efficacy is not an invention, Your Lordships. The underlying API glucagon was already protected under the first patent, which is the compound patent in this case, which arbitrarily expired in September 2024, Your Lordships. And the impugned patent merely repackages the same known API with excipients and a delivery device, thereby attempting to extend the monopoly beyond the life of the original patent, Your Lordships. And this is precisely the mischief that Section 3 Clause D seeks to prevent, Your Lordships. With regards to the same, if Your Lordships could, if I may direct you to page 38 of the companion, Your Lordships. Your Lordships, in the case of Novartis versus AG versus Union of India, the stated that, so if Your Lordships are with me, para 84, Your Lordships, from the last is the 6th line, a mere discovery of a new form of a known substance can never ordinarily meet the threshold of novelty, an inventive step under clauses J and JA of Section 2 Clause 1. An invention cannot be characterized by the word mere. The word invention is distinct from the word discovery, Your Lordships. And in this case, the Supreme Court made it clear that India has consciously adopted a stricter inventiveness standard for pharmaceutical inventions driven by public health considerations, Your Lordships. And the routine excipient optimization, formulation stabilization, or the delivery refinement, howsoever sophisticated, do not meet the this elevated threshold that's laid on in Novartis AG case, Your Lordships.
You say this is a mere discovery of a known substance, the formulation.
Indeed, Your Lordships.
How do you say that?
Your Lordships, the contention is not with respect to the API, Your Lordship, but with the specification that's being made that if Your Lordship could refer back 3.
Discovery is finding something which is existing.
Indeed, Your
Correct.
Lordship. Indeed, Your Lordship.
What was existing was the API.
Indeed, Your Lordship.
Right?
Indeed.
Now they add certain excipients to give it stability.
Indeed.
And according to them, this increases the probably what is the term that is used? Patient compliance.
Indeed,
right?
they've mentioned. Yeah.
So,
Indeed.
how do you say that adding the excipient to the API is discovery of a known substance, which is
Indeed.
something which is available?
The council would be proving the further assumption, Your Lordships, because the impugned
Why
way-
don't you tell it now?
because the
Your
impugned
friend
formula-
also said the same thing. Now I'm confused whether all the questions have been answered or not.
Yeah, Your Lordships, I'll answer the question. Because formulation patent does not introduce a new molecule, Your Lordships, not a new mechanism, not a therapeutic pathway, Your Lordships. As mentioned in the case of Novartis, there is no therapeutic efficacy, which will also be proved in my further submission, Your Lordships. And
How do you say there is no therapeutic efficacy?
Wasn't
Because that is what I'm trying to say.
But wasn't that case regarding the molecule? Like it was with respect to the API, it was an active pharmaceutical ingredient and that case doesn't refer to any formulation. So I do not understand how we will be justifying by this.
This way we're talking about discovery of a known substance. Something which is available, you discover,
indeed, Your Lordships.
right? But this is a formulation that they made the compound.
Indeed, Your
And
Lordships.
now there is an addition to that.
Indeed, Your Lordships.
So where is the question of a discovery of a known substance?
Your Lordships, its query does not satisfy the test of enhanced efficacy to prove the first point being the therapeutic efficacy. And with regard to the same question, Your Lordships, I would like to make this submission consistently. Merrill Pharmaceuticals and Hedgen Norton's case, it recognizes product patent lacks novelty or the entity is already known, Your Lordships. And if Your Lordships could refer page 35 of the compendium to answer the question, Your Lordships. The para 105, the last line, Your Lordships, para 105, from last is the 4th line. It follows that if it can be shown that such physical entity, that is a compound, is already in the state of the art for example in the context of a particular activity, then a claim to the physical entity per se lacks novelty or logic. And in this case, the House of Lords held Merrill Pharmaceuticals tried to extend its monopoly on the antihistamine drug by patenting its acid metabolite. The court ruled against Merrill as the metabolite wasn't novel because the original antihistamine drug worked, and therefore metabolite was already anticipated, so it couldn't be patented. And in this case, the API had already worked, and therefore in this case it cannot be patented at the same time because it's a known substance which is repackaging the same API in the formulation patent. And if that satisfies your the question, the council needs to move it further.
Packaging is different from what is, this is not a metabolite. Okay. Their case is not with respect to a new form of a known substance. This is a formulation which according to them has certain excipients and is able to provide and reduce the drug degradation and improve patent compliance.
Your Lordships, if your Lordships could refer paragraph 10 of the proposition, which says vehemently opposes the counterclaim, arguing that the formulation patent represents a genuine and significant invention, and it claims the new formulation solves critical issues of drug degradation and improved patient complaints. It's a mere allegation that's been made by the plaintiff, your Lordships, and therefore there is no proof as to whether it solved the drug degradation or not. And even with respect to the
wouldn't that have been taken care of at the time of grant of patent unless they had shown that there was an inventive step?
Your Lordship, the same is silent on in the proposition.
So no, I'm just asking on the concept of law itself.
Indeed.
Unless it crossed the threshold of 21JA, the patent would not have been granted.
Indeed.
It's an inventive step, and insofar as this case is concerned, the inventive step, even according to them, is that there is enhanced stability,
Indeed.
probably bioavailability or
Indeed.
whatever you can call it. So,
Your Lordships, to answer the same as pointed out by my co-counsel, just because the patent has been granted doesn't mean that it's valid, Your Lordships.
absolutely. No, I think we talked
But
about it.
no, Your Lordship, that it can still be we can still claim the validity of the patent. And the same will be true that upon proving the invalidity, even the device that was used in our case will be immaterial to this particular case, Your Lordships, and the same will be true, Your Lordships. And Your Lordship, the next submission being the section 3+D operates independently and ex ante, even if novelty or inventive step was assumed, Your Lordships. The plaintiff may contend that the formulation patent satisfies section 1+D and section 1+A. However, such a contention is legally untenable in light of the Novartis AG case, where the Supreme Court categorically held that section 3+D is a substantive and independent threshold and not just a mere classificatory provision, Your Lordships. And even argument, though, assuming the novelty or inventive step, a pharmaceutical invention must still demonstrate enhanced therapeutic efficacy to cross the section 3+D bar, Your Lordships. And improvements that they've claimed in terms of stability, patient complaint, shelf life were expressly held in Novartis to be insufficient to satisfy this requirement. And applying this settled position of the case, the present case, Your Lordships.
That is the facts of that case, isn't it?
Your Lordships.
Novartis, whatever you're saying, see, one thing is the point of law that it holds. The other is on the facts of the case. In the facts of that case, probably there is no enhanced therapeutic effect. So far as the facts of this case is concerned, I think you will agree that if they are able to show an enhanced therapeutic effect,
Indeed.
then it will be an inventive step.
Indeed,
Is it
Your
not?
Lordships. Indeed.
Therefore, you will have to address on those facts while they claim
Indeed.
that the addition of an excipient is
Indeed.
what makes the API more stable. Unless your argument is going to be that it cannot,
Indeed.
then it will definitely satisfy the requirement of 21J.
Indeed.
Right? So there is no point in quoting the law without linking it to the fact.
Indeed, Your Lordships. Your Lordships, if I could refer to page 48 of the complaint to answer your question, Your Lordships, in the case of Vishwanath Prasad versus Hindustan case, para 21, Your Lordships, 8th line, mere collection of more than one integers of things not involving the exercise of any inventive faculty does not qualify for the grant of a patent. And it is not enough, said Lord David Rickman versus Theory, and again international case, which is quoted in this case, Your Lordships, that the purpose is new or that there is novelty in the application, so that the article produced is in that sense new, but there must be novelty in the mode of application. Furthermore, or there must be some ingenuity in the mode of mode of making the adoption, Your Lordships. In this case, they have claimed that it is a synergistic thing, and your lordships, as far as the council understands and also it's been accepted by the plaintiff, synergy means combined effect that is produced that produces greater effect when combined than effect produced when independently or separately acted, your lordships. In this case, they also attract this particular synergistic effect with regards to subcutaneous administration, your lordships. Subcutaneous administration, in this case, your lordships, refers to injecting the drug into the tissue into the body beneath the skin, your lordships. And therefore, the plaintiff's reliance on subcutaneous administration and alleged improvement in the drug is a red herring and does not rescue the immediate formulation patent from invalidity, because subcutaneous administration in essence is not a technical invention but a well-known and conventional mode of drug delivery in pharmaceutical science, your lordships. And
see, suppose the drug were to be made in a form that it will be orally consumed, right? And there is no stability to that formulation. No, the compound is there. Okay, the way it is administered could be multiple, right? Now, if you come up with a formulation that involves, giving this drug, delivering it to a patient in a subcutaneous form, and that results in greater, efficacy insofar as patient compliance is concerned, because the patient is able to probably use it himself. The oral formulation is not stable.
indeed, your lordships.
Then how would you say that this is not an inventive step for greater therapeutic efficiency?
Yeah, your lordships, assuming that there is a synergistic effect.
Because you said that subcutaneous injection by itself is not, something.
It's not an inventive step at all.
Therefore, I'm, juxtaposing that with the oral formulation. Obviously, when you specifically say subcutaneous, that is a comparison with other forms of delivery of the drug.
Your lordships, it is possible to have a combination that is synergistic, but the actual scientific and biological thing will still not be potent enough to reach a clinically meaningful effect in humans, your lordships, and that is exactly why the therapeutic efficacy should be attained to prove the inventive step being
Which is what they're claiming, that the subcutaneous
Your lordships, they are claiming with regards to the synergistic step that they've taken into consideration, and in this particular case, your lordships, even assuming that there is a synergistic application in this particular formulation patent, there is no therapeutic efficacy because there is no absolute ability of the treatment to produce a desirable clinical outcome in the patient, your lordships, and therefore the patient complaints or the delivery device in itself will not satisfy this particular requirement, your lordships. And if your lordships are satisfied with my answer, the council would move on with my next argument. Your lordships, applying this settled position to the present case, the improved formulation does not disclose any enhancement in therapeutic efficacy, and the benefits asserted by the plaintiff, namely improved stability and ease of subcutaneous administration. With regards to subcutaneous administration, your lordships, the same is not a technical invention but a well-known conventional form of drug delivery in the pharmaceutical science, your lordships. It forms part of common general knowledge in pharmaceutical science, and it's only a clinical preference and not a patentable advance, your lordships. And secondly, permitting patent protection on the basis of routine formulation adjustments or through the route of administrative settings or the changes would defect the legislative intent and behind the 2005 amendment that we made in the Madras AG Union of India, and Section 3+D, which was introduced precisely to curb the incremental modifications designed to extend monopoly over known pharmaceutical substance, your lordships. And the same was again held in the case of Vishwanath Prasad, your lordships. If your lordship could refer page 50 of the compendium. The first para, line 4, your lordships. Line 8, your lordships. It would have been obvious to any skilled worker in the field, in the state of knowledge existing in the date of patent, of what was publicly known or practiced before about this process, and that the claim in question, namely mere addition of a liver bracket in that case.
Why did you do
in this
it
case,
from 2006?
Your Lordships, yes, if you could,
The patent expires in 2026. Therefore, application is made possibly in 2006, right? Probably the grammar came, let us assume, 2 years later, right? So you had at least 17 years to do this. If it is something that could have been done, it was so obvious, why did you not do it for 17 years?
Your Lordships, we did not file this suit as we didn't look at the patent when it was granted, as it was granted, thinking that it was valid. And therefore, but upon the plaintiff's patent infringement suit, we looked into this patent of, we looked into the formulation patent and found that there are grounds.
No, I am not asking you why you did not sue. I am asking you why could you have not come up with, a formulation using the API, if, the addition of excipients or the, subcutaneous injection form is obvious.
Your Lordships, the same will be answered. Your Lordships, the next submission being, if I may invoke this particular doctrine of inherent application, which bars the monetization of inevitable results. Under this case, Your Lordships, Sharing Corporation versus Geneva Pharmaceuticals, if Your Lordships could refer page 37 of the compendium. Your Lordships are with me. Para 117, Your Lordships. Based on the above, the beta crystalline version automatically results from the teaching to the prior art. It is anticipated, even if the skilled person is unable to identify or characterize it. From this judgment, the doctrine of inherent anticipation prohibits monopolizing effects that inevitably flow from prior art combinations. And stability and the suitability for subcutaneous administration are natural consequences, just mere natural consequences of combining a known API with standard excipients and a delivery device in this case. And the formulation patent merely claims these inevitable outcomes without disclosing any new technical advances that being made in the formulation patent. Therefore, it does not enhance the stability, it does not enhance the therapeutic efficacy, and rendering it invalid under the section and revocation under section 64 of the patent act because of double patenting or retained damages. And Your Lordships, also in the case of Best Agro Limited versus Controller of Patents, it characterized section 3 clause D as a second tier safeguard against pharmaceutical evergreening. Your Lordships, if Your Lordship could refer paragraph page 45 of the compendium. First paragraph, it's fifth line, sorry. Section 3 clause D is meant especially to deal with chemical substances and more particularly pharmaceutical products derivatives. The amended portion of section 3 clause D clearly sets up a second tier of qualifying standards for chemical substances, pharmaceutical products in order to leave the door open for true and genuine inventions, but at the same time to check any attempted repetitive patenting or extension of the patent term and spurious counsel being made. And in this case, Your Lordships, the caution that that incremental or routine improvements cannot be permitted to prolong exclusivity over a particular patent over known substances. In this case, the known substance being the API, and also the excipients of the stability and delivery device, as I said, those are not valid essential that satisfy this particular requirement. And read purposely in the case of as mandated in RBA versus Peerless General Finance, section 3 clause D reflects Parliament's intent to protect the to impose heightened scrutiny on pharmaceutical patents post 2005 amendment. That's again mentioned in the Novartis case, Your Lordships. And permitting protection for mere reformulations or for the known patents would defeat this legislative intent. And the claimed benefits of stability and patient compliance here do not amount to enhanced therapeutic efficacy in this case, Your Lordships. My final submission being the formulation patent also lacks inventive step under section 2 clause 1 clause JA, Your Lordships. For the same, Your Lordships could refer paragraph page 40 of the compendium, Your Lordships. Your Lordships, independently of section 3 clause D, the difference summons that the accused patent face the inventive step requirement and section under section 2 clause 1 clause JA, which defines what an inventive step is. And in Monsanto Co versus Coromandel Intact case, the Supreme Court held that where an invention can be arrived at by a person skilled in the art using a common general knowledge, it lacks real inventiveness, Your Lordships. And pharmaceutical formulation using using excipients for stability or patient compliance in terms of the subcutaneous delivery system that's been claimed by the plaintiff, were well-known techniques long prior to the priority date reductions, and this impugned patent discloses no unexpected technical effect or non-obvious advancement. As you pointed out, there is no surprise in the elementary reductions. And furthermore, the Supreme Court felt that patents lacking real inventiveness, where the formula or use was already known to persons skilled in the art, are liable to be revocated under Section 64, if I may just conclude in 1 minute. Revocated under Sections 64 plus 1 plus D and E allotments. Applying this ratio, pharmaceutical products or formulation methods, stability optimization through excipients, and subcutaneous delivery systems were part of common general knowledge, and which were prior to 2010 allotments, rendering the formulation patent neither novel nor inventive, and thus unknown, and thus vulnerable to revocation allotments. And to conclude allotments, the formulation patent constitutes impermissible evergreening, lacks enhanced therapeutic efficacy under Section 3 clause D, and fails the inventive step requirement under Section 2 plus 1 plus JA, and allowing enforcement of such a patent would undermine the carefully calibrated balance struck by the Patents Act, Patents Act, and defeat the objectives of the 2005 amendment and the Parliament's intent allotments. And the formulation patent is therefore prima facie invalid and undeserving of protection. If you are satisfied with the arguments provided for the third issue, the council seeks permission to move the claim. Therefore, in light of the issues raised, arguments advanced and authorities cited, may this Honorable High Court of Madras be pleased to adjudge declare that the manufacturing activities carried out by the defendant fall under the Border exemption under Section 107A of the Patent Act, and hold against any injunctive period by the plaintiff, and furthermore provide for damages proportional to the cost of dismissal. The defendant's manufacturing activities do not constitute infringement of formulation patent. The formulation patent is an impermissible act of attempted evergreening, and is therefore liable to be revocated under Section 3 plus D, Section 2 plus 1 JA, and Section 64 of the Patent Act Adopted, and or pass initial charges that deem fit in the interest of justice, equity, and good conscience, and all which some data that we submitted before this court. Much of that. There's an honor. I think before this court.
Council seeks permission to approach the dice for rebuttal. I'd like to state my orders due to the contentions raised by the defendants in their arguments. Firstly, that there was a contention with regards to the settlement agreement, and that it happened in the United Kingdom, and it would not be of relevance in the Delhi High Court. Also, the Delhi High Court has its own patent rules specifically to speed up the process of patent litigation, and the rule there is a rule specifying that settlement agreements which happen in foreign countries are also of relevance for the same. In addition to that, Your Lordship, considering that it's a parallel litigation, the Council believes it is safe to assume the facts are identical, and it is in relation to the similar formulation patent as well. However, it is not that the settlement agreement per se is invalid, it acts as them acknowledging the same. In addition to the same, Your Lordship, with regards to the negotiations, it was stated by the Learned Counsel for the defendants that the negotiations were only for the purpose of selling within Indus line. As per their claim is that they are manufacturing only what is required for regulatory approval exportation. If that is the case, as per the Bayer vs. Union of India guidelines, they are required to disclose the quantity of the regulatory authority, what is required, and their manufacturing scale as well. So, disclosing the same is their duty as per the Bayer vs. Union of India guidelines. Another argument was made that they did not have to disclose it to us prior to starting with the manufacture. I'd like to rebut it by saying that they did not actually have to disclose it prior, but right now we are requesting them to disclose the same, and for the purpose of ensuring they are not commercially stockpiling, we are also requesting this court to seize all the manufactured goods here. And they also admitted that they are in a position to give an undertaking to the effect that they would not be selling in India until the expiry of the patent. Your Lordship, our concern was not with whether or not they'd sell in India with regard to the expiry of the patent. If they are commercially manufacturing the drugs within India, that itself would amount to violation of the rights of the patentee. On the date of the patent, if they decide to sell the drugs, as Your Lordship had rightfully pointed out, that would also amount to infringement because they had manufactured the drugs at a point when the patent was still valid, and it is not the Bolar exception would not be applicable in said example, Your Lordship. And in addition, Your Lordship, they repeatedly stated that they relied on WHO document and repeatedly stated that regulatory authorities' quantity cannot be properly determined. Our prayer is the same. We require to determine the quantity, which is why we're ordering an injunction to stop whatever they have manufactured so far, so we don't suffer further losses, and to seize the devices so we can determine the quantity. We are asking this court to pass an order to be in a position to determine what quantity they're producing and whether it falls under the Bolar exception or not. And there was also another argument raised that we were asking for compensation. We'd like to clarify, at no point have we raised any question of compensation yet, because we are not sure of what the quantity is.
The issue was that they're asking for compensation. They said compensation could be an adequate remedy.
Certainly, Your Lordship. We still are apprehending a possibility of danger, and that being the case, we approach for a coagulament action. So we'd like to prevent a damage from being done rather than seek for compensation. In addition, Your Lordship,
If the settlement was in respect of the same issue, would it not have been your case that they had breach of the settlement?
Your Lordship,
Not exactly the case with you.
Your Lordship, that settlement agreement was in regards to United Kingdom. It shows the intent of the companies. Patent law being territorial, the settlement from UK would not be as it is binding upon it. But clearly, the fact that they are ready to accept the patent in United Kingdom shows that in India they are aware that it is a valid patent, but still chose to infringe. So may I continue here? Much another point that they stated was that they are not exporting for the purpose of sale, and that there is not a commercial quantity. And in line with this, and in line with another question that was posed to me during my argument, I'd like to answer the same as well, Your Ladyship. It asked me whether the Canada case has any other relevance other than the API being concerned. Lordship, in page 217 of our company, I read out the relevant portion as well. The panel considered whether the market advantage gained by the patent owner in the months after expiration of the patent would also be considered as a purpose of the patent owner's rights, and they ruled in the positive. So the restriction placed upon them with regards to any patent, in the instant case the formulation patent, the restriction placed upon them to prevent them from manufacturing until the date of expiry of patent is part of the patent owner's rights in the instant case and to another argument was raised by them that they had cited the case of 10HC wireless versus Mobi antenna. However, in the very same case that they had cited, there were two main reasons for revocation which was ordered in that case. First is that it was a recent patent, and second is that a prior article was shown. And with regards to the prior article as well, there were several points raised that subcutaneous administration is something any person ordinarily skilled in the art would have been capable of knowing. But to first revoke the patent based on prior art, just a minute to wind up with this argument. To revoke a patent based on prior art, they should have shown that at the time of applying the patent, there a prior art existed. So prior to 2006, a formulation and a delivery device similar to what we have acquired a patent for should have existed, Your Lordship, and they have failed to show any such prior art existing in the current case. And in addition, subcutaneous administration does not necessarily mean it has to be a syringe. It could have been packaged with automatically injecting syringes. And even recently, there was development diabetic medicine wherein it could have been administered to the nasal cavity just through breathing. So these are the development that happened in this field. And in 2006, we made this development through our formulation and the delivery device, and hence that is why we were granted the patent for the same aspect. If there are no other questions, the council would like to. Thank you, Your Lordship. It was an honor arguing before this.
Your Lordship, before going to the requirements of what the said, you had asked me a question that we had 17 years, why didn't we use the API to come up with a similar formulation? Your Lordship, we did not actually have 17 years because we are not containing the invalidity or validity of the first API. That was a groundbreaking invention that we accept. So we did not have 17 years. Only post the expiry of the API did we have a time for developing a formulation, which we did. Now moving on to there. First of all, Your Lordship, the first point was that the parallel litigation has to be accepted. Your Lordship, as I had already submitted, parallel litigation, the subject matter of the agreement and the subject matter of the case itself would have been different. And it is not a safe assumption to pluck out of thin air and say that it was the same case there and you have settled here and you have to settle in Indus Land as well. Your Lordship, moving forward, most of the rebuttals were that we have to prove or we have to signify the quantity. Your Lordship, as I had already submitted, this is the first stage of the suit, and hence the same can be done in the due course of the suit. An undertaking with regards to the commercial stockpiling aspect of this can be done. And an undertaking, if they want, we also can give an undertaking that we will not sell the product till the expiry of the patent, even in Equatoria and Corsicana, because that is not our intent. Our intent is only to meet the regulatory requirements as already submitted. And finally, Your Lordship, they mentioned 10xc case. Your Lordship, 10xc case was referred to drive home the point that the validity of the patent cannot be presumed just because they have a granted patent. And even rebutting his point that in 10xc case there was a prior article. Your Lordship, prior article is just one ground of revocation under 64. The ground we have relied here for revocation is not a presence of a prior article, but the evergreening aspect of it, Your Lordship. Hence, if Your Lordship is convinced, I would like to wind up my arguments. It was an absolute pleasure.